All stand and remain standing until the conclusion of the reading of the proclamation. Ladies and gentlemen, the proclamation. All persons having any business before this honorable court now draw nigh. Give your attendance, and you shall be heard.
Ceremony to farewell the Honourable Justice Paul Brereton.
I begin, as is now customary and appropriate, by paying the court's sincere respects to the Gadigal of the Eora Nation, the traditional custodians of the land on which we meet, and to their elders past and present, and I extend those respects to all First Nations people. This morning we sit ceremonially to mark the end of almost 18 years of distinguished service on this court by the Honourable Justice Paul Brereton, AM, RFD, and to wish his honour well as he assumes leadership of the National Anti-Corruption Commission, a most significant responsibility for which he is exceptionally well equipped. I acknowledge the presence in court today of Justices Gageler, Gleeson and Jago of the High Court, Justice Kirby, formerly of the High Court, former Chief Justice Bathurst, Justice Alstergren, the Chief Justice of the Federal Circuit and Family Court of Australia, the Chief Judge of the Land and Environment Court, the Chief Magistrate, and other current and former judicial officers from a range of courts, including the Supreme Court and the Federal Courts, Federal and Family Courts, that is, and many other distinguished guests. I also formally note the apologies of former Chief Justices Gleeson and Spiegelman, the Chief of the Defence Force, General Angus Campbell, AODSC, and the President of the Defence Force Disciplinary Tribunal, Justice John Logan, RFD. I single out for special welcome Justice Brereton's wife Sue on the AVL link, their daughters who are here in person, Josephine and Catherine, and their partners Scott and Daniel, his honour's brother, Dr. John Brereton, and his family, and his aunt, Mrs. Robin Stevenson. I also acknowledge the presence here today of a number of distinguished serving and retired senior officers of the permanent and reserve forces, and I acknowledge General Mellick, who I'm pleased to see sitting at the bar table. Finally, in terms of acknowledgement, His Honour's long-time associate, Ms. Julianne Reid, is sitting on the Associates bench today, and I thank her for her dedicated service to the court over many years. Justice Paul Le Brereton marched onto the Supreme Court on the 15th of August 2005, bringing with him the reputation as one of the most versatile and able barristers of his generation, a counsel of extraordinary tenacity, indefatigable, with vast reserves of energy and of the utmost integrity. At the time of his appointment, he was equally at home in a murder trial, in a probate suit, claims alleging professional negligence, where he was the counsel of choice for the Medical Defence Union for many years, in professional disciplinary tribunals, and before the Court of Appeal and the High Court of Australia. He was, rather remarkably, in light of all that I've already said, also one of the country's leading and most respected family lawyers, who in many people's eyes could have made an outstanding Chief Justice of the Family Court of Australia. 3 current members of this court, Justices Meek, Weinstein and I, each had the good fortune to read with His Honour when he was a senior junior. We learned many things, including the fact that Brereton was not a morning person, principally because he would be up until the early hours finalising advices, polishing submissions and plotting incisive cross-examinations. It was never entirely clear as to whether he would arrive before or after the case was called on for hearing of a morning. So it was extremely, I think we fastened on the word exhilarating, to be his junior at that time. In terms of punctuality, while it would be an exaggeration and unfair to say that nothing much has changed over the last 18 years, I'm delighted that His Honour was able to make this ceremony on time today. The extraordinary versatility which pervaded His Honour's career at the bar continued during his judicial career, and although appointed to the Equity Division, in his early years he sat regularly for a month or two each year in the Common Law Division. That versatility and the breadth of his experience and expertise has also been hugely beneficial during his time on the Court of Appeal, to which he was appointed in 2018. Of course, the versatility of which I have spoken has been underpinned by a deep and broad legal knowledge, great technical ability, and I should add, a never to be underestimated mastery of practice and procedure. This was especially in evidence during His Honour's service as the Corporation's list judge, as well as in duty lists. Some of His Honour's perhaps less heralded work, but of immense importance, has been in the area of adoptions, as well as in the Court's parens patriae jurisdiction. Insofar as adoptions matters are concerned, Justice Brereton delivered judgments in some 65 cases, which gave important and sensitive guidance in this most delicate but important area. Those decisions included the adoption of NG, number 2, a much cited judgment concerning the effects of adoption and their role in determining whether adoption is clearly preferable in the child's best interest. The case of JLK and CRK concerning the proper approach to Section 67 1D of the Adoption Act, dealing with the dispensing of consent of biological parents, where the proposed adoptive parents are already authorised carers or guardians for the child. And the adoption of BR in 2018, the first judgment concerning the application of the Aboriginal Child Placement Principles in Section 35 of the Adoption Act. These examples of Justice Brereton's work in this area were supplemented by important contributions to the Court's parens patriae jurisdiction and more broadly to the Court's protective function. The Court's website lists many of his extrajudicial speeches in this area, including papers on children's issues in the Supreme Court, on acting for the incapable, a delicate balance, on the origins and evolution of the parens patriae jurisdiction, and another paper on the High Court and family law, 2 recent excursions. Added to these contributions is His Honour's decision in Re Elm concerning an expectant mother who had HIV, did not propose to take steps to protect the child from contracting HIV. In that case, His Honour explained the relevant principles for the authorisation of medical treatment following the assumption of parental responsibility by the Director General of the Department of Community Services. So too the case of Re Justice Health in 2011 concerning the legality of the discontinuation of all life-sustaining treatment in a prison context. Another important chapter in His Honour's extensive judicial contribution lies in the field of corporations law. The Australian Corporations and Securities Reports are replete with his decisions, many delivered either extempore or with great expedition, but always with close attention to detail, characteristics of this Court's corporations list, which have continued under the strong leadership of Justice Ashley Black. Some of Justice Brereton's leading decisions in the corporations field include ASIC and Maxwell, a commonly cited judgment on directors' duties and shareholder ratification, as well as on misleading and deceptive conduct. one of the HIH cases concerning the accessorial liability of subsidiary companies and the test for causation when considering the loss that arises from misleading and deceptive conduct. Hancock and Reinhardt, a very complex trust case, to say the least, involving issues of fraud on a power, replacement of trustees, and the taking of an account. Mapeki and Airport Fine Foods, holding that the denial of a legitimate expectation is sufficient to ground a claim for relief for oppression, and they amongst literally hundreds of decisions in the corporations list. In His Honour's 13 years as a divisional judge prior to his elevation to the Court of Appeal, Case Law New South Wales searches indicate that His Honour delivered over 1,500 decisions, averaging approximately 120 decisions a year. That is a phenomenal output, but sheer numbers, however impressive, do not and cannot do justice to the invariable quality of those judgments, many of which related to hearings over multiple days or weeks. I know that, I did a number of them. As every judge and practitioner in this courtroom knows, those judgments of His Honour are full of learning and clear distillation of principle. His Honour's decisions are regularly cited, not only at first instance, but in appellate courts throughout the country, as well as in the coordinate corporations law and other national federal jurisdictions. Other general equity decisions of note reported in the New South Wales law reports include Kalinikos and Hunt, concerning the relevant test to be applied in the court's inherent jurisdiction and applications to restrain a solicitor from acting for parties in a matter where the solicitor may be a material witness. In the case, Michael Wilson and Partners and Nichols, concerning the possibility of objecting to an order for discovery where compliance with that order would involve contravention of foreign law. Lameri Holdings, holding the former trustee is not entitled to retain as against a successor trustee trust assets as security for an accrued right of indemnity out of those assets. Colourfully, Hitchcock and Pratt, concerning the extraterritorial operation of the Succession Act, insofar as it purports to affect estates of those domiciled outside of New South Wales. Steinmetz and Shannon, but the list goes on and on and on. Such was the significance of His Honour's work. On the Court of Appeal and in the Court of Criminal Appeal, His Honour has participated in a further 270 decisions, including many of note, including Goshen, the Medical Council of New South Wales, an important decision concerning NCAT's role as the appellate body for decisions from the Medical Council and the manner in which such de novo hearings should be conducted. Sidoti and Hardy, concerning title to land by adverse possession in circumstances where the adverse possession began prior to the conversion of the subject land from old system to Torrens title. Michael Wilson and Partners and Emmett, another case in that long line of litigation, this time concerning personal jurisdiction, service outside the jurisdiction, and the test of a real and substantial connection to Australia in the context of a partnership which primarily carried on business overseas. And recently, last year, Twig and Twig, an extraordinarily complex case involving fiduciary duties, constructive trusts, trustees de sang tort, laches, tracing and limitation periods in respect of the misappropriation of funds from a large family group. Justice Brereton's prodigious output as a judge of this court over so many years has been matched by few, if any, and this record of achievement is all the more remarkable when one overlays it with his multiple extracurricular activities. Within the court, His Honour has served on a number of Supreme Court committees, including as a member of the Building Committee from the time of his appointment, as a member of the Heritage Committee between 2007 and 2009, as a very dedicated chair of the Costs Assessment Rules Committee from 2016 to the present. His Honour also chaired the Costs Assessment User Group from 2006, in which capacity His Honour in 2012 led the review into the Costs Assessment Scheme. Whilst Adoptions List Judge, His Honour chaired the User Group and similarly when the Corporations List Judge. From 2007 to 2016, His Honour was the Chief Justice's nominee on the Law Extension Committee at the University of Sydney. And from 2015, His Honour sat on the Harmonisation Committee, responsible for the harmonisation of rules in courts across Australia, including the Federal Court of Australia. Still within the law's domain, Justice Brereton has also served as a part-time member and deputy chairperson of the New South Wales Law Reform Commission since 2016, and has also somehow found the time to join Professor Martin Davies and me, and latterly Michael Douglas, in producing 3 editions of Nye's Conflicts of Laws, where he has written in each edition 10 chapters, including those on family law, trusts and succession. Pause. It's exhausting to recite this. But we move on to perhaps the most well-known and significant of His Honour's extracurricular engagements. That is His Honour's long, deep and distinguished contribution to the armed services, most notably, but not only, the Australian Army. That particular line of duty began in the Army Reserve in the Sydney University Regiment in 1975. And since then, His Honour has held a succession of ever more senior posts, including most recently as Assistant Inspector General of the ADF, and prior to that as Head of the Cadet Reserve and Employer Support Division. These positions culminated in the award in 2010 of membership of the Order of Australia in the Military Division and his appointment as Major General. In that context, you'll be pleased to know that I shall refrain from any reference to the Pirates of Penzance and Gilbert and Sullivan more generally, other than to note that on the Court of Appeal, we have generally looked to Justice Leeming rather than Justice Brereton for many useful facts about the square of the hypotenuse. Justice Brereton has spoken frequently and extrajudicially on important military topics, including the role of the Director of Military Prosecutions, the Afghanistan charges and the rule of law, on military justice and Chapter 3, the constitutional basis of courts martial, a historical lecture on Lieutenant General James Gordon Legg, an important paper on psychological injury in veterans and the law. Justice Brereton also remains the Deputy President of the Defence Force Disciplinary Appeal Tribunal, which is constituted solely by serving judges and hears appeals against convictions by service tribunals in respect of service offences. It is the equivalent of the military's Court of Criminal Appeal and ensures the independence of ADF discipline and justice. The President of that tribunal, Justice Logan of the Federal Court, has asked me to convey his sincere appreciation to Justice Brereton for his service, as indeed has General Campbell. The work undertaken by Justice Brereton between 2016 and 2020, reflected in his eponymous report into alleged war crimes committed by Australian soldiers in Afghanistan between 2005 and 2016, is a testament to His Honour's characteristic thoroughness and meticulous attention to detail, and speaks to His Honour's willingness to do difficult, in some quarters deeply unpopular, work without fear or favour, and with great courage and perseverance. The state of New South Wales has been immensely fortunate to have had a judge of Justice Brereton's calibre, unstinting dedication and remarkable energy to have served it for so long in such a distinguished manner. The nation is equally fortunate that, apart from his almost 50 years of service to the armed forces, His Honour will be the first occupant of a most important public office as the inaugural National Anti-Corruption Commissioner. Justice Brereton will bring to that office all of the qualities of which I have spoken, together with his fierce independence, courage and conviction. Justice Brereton, on behalf of the court which you have served for so long, and on my own behalf as a friend, I thank you for your magnificent, extended and extensive contribution and wish you well in your latest challenge. You start on Thursday. Ms. Bashir, President of the New South Wales Bar Association.
May it please the Court, I acknowledge the traditional custodians of the land on which we meet, the Gadigal people, one of 29 clans of the Eora Nation, and pay my respects to their elders past and present. I extend sincere respect to other First Nations people here with us today. It is a great privilege to represent the New South Wales Bar in marking Your Honour Justice Brereton, AM, RFD's retirement from the judiciary, and in paying tribute to your eminent contributions to the law as both judge and scholar. The Chief Justice has given a survey of both the immense quantity over a breadth of practice areas and the singular quality of Your Honour's learned judgments. The expanse of Your Honour's knowledge and skill was evident at an early stage in your career at the bar, where you ran all manner of trials and appeals of astounding variety and complexity. Senior members of the judiciary and bar credit the sheer breadth of Your Honour's intellect and proficiency commitment to continuing to provide advocacy services to small suburban and country firms long after you were in great demand. Your redoubtable intellect was applied, whether the case be one of family law, equity, common law, corporations, or criminal law. Your Honour did not flinch when taking on difficult and unpopular cases, advocating for defendants accused of professional misconduct or medical malpractice, and on occasion, murder. One of our preeminent advocates has described you as the most formidable opponent that I have ever come across, whose mastery of the materials and the law meant that you were completely directing the proceedings from the bar table. Opponents found themselves outflanked at every turn. A consummate polymath of the law, Your Honour appeared from the local court to the High Court, showing leadership on the ground and across the field, and confounding those trying to categorise you as either generalist or specialist. Your Honour's faithful adherence to the cab rank rule set a stellar example for your readers, continues to inspire, and will be of ongoing influence to those fresh from the bar practice course here today. Your Honour gained the respect of the bar long before taking silk in 1998. When first called to the bar in 1987, it soon became apparent that even as a solicitor, Your Honour had already appeared on your own in a great number of reported cases. As a young solicitor, Your Honour had appeared in the Court of Appeal, predominantly in land and environment appeals. The Court of Appeal then included Justice Michael Kirby, who recalls that you were brilliant, in total command of the case, incisive and with a mordant wit. Then Justice Kirby encouraged you to take your natural place at the bar, so you would be available for all solicitors to brief. A few months later, Your Honour resumed appearances, now in robes and with a flourishing practice as a young junior barrister at 3 Wentworth, where you remained a loyal member until your appointment to the Supreme Court in 2005. Your Honour's prodigious work ethic at the bar was renowned. Your Honour was perhaps working by the maxim attributed to General Eisenhower that plans are worthless, but planning is everything. Your Honour kept long hours in chambers, accompanied by a large pot of tea, acting as a tireless and adroit advocate for each of your clients, and no doubt endeavouring to teach a young belle discipline and perhaps a few formations and tactical manoeuvres, such as how to be in defilade, performance of pincer moves, or shaking out. I have heard that the Chief Justice regularly performs patrols in the court, albeit disguised as dropping in for a chat. When Justice Sakar was still at the bar, he once thought he might be surrounded in 2009 when arguing a case on private international law, finding Your Honour on the bench, and at the other end of the bar table from him, none other than said Bell, the other expert on the topic, now an adjunct professor and your co-author on Nye's Conflict of Laws in Australia. Of course, Your Honour was none other than utterly fair in that matter. Your Honour's indefatigable diligence did not cease on appointment in 2005. Your enormous capacity for work was complemented by the skilled delivery of extempore judgments, reserving before lunch, with masterful ex-temp reasons delivered after lunch, so precise they required little editing for court reporting purposes. Your Honour leaves an abundance of beautifully written and well-reasoned judgments that remain a delight for counsel to cite and read. To name but a few in addition to those already listed today, Cactus Imaging Proprietary Limited and Peters, and Tullett Preborn Australia Proprietary Limited and Purcell, the 2008 case, both leading authorities on restraints of trade. Valczewski and Valczewski, dealing authoritatively with the accrued jurisdiction of the family court and the transference of proceedings to that court for the New South Wales Supreme Court. Re Justice Health, we've already heard about, in relation to the court's parens patriae jurisdiction and sustenance of life in a custodial setting. Director General Reid Thomas, on the scope of this court's parens patriae jurisdiction in the context of the involuntary detention of a seriously mentally ill child in secure accommodation, and Maritime Authority of New South Wales and ROFE, where Your Honour delivered the authoritative judgment on criminal negligence and recklessness under the Maritime Safety Act. Many judgments are replete with Your Honour's innate humanity and acute appreciation of the vulnerability of children, those lacking in capacity, and others at severe disadvantage and in need of protection. They reflect a steady application of principle in the resolution of the exquisitely difficult crises that such matters present to the court. Your Honour has been a model of civility and courtesy to counsels and party appearing before you, and it is no surprise that Your Honour has a large circle of not only readers but also former tipstaves who remain devotees. This is in no small part due to Your Honour's acts of personal kindness and generosity towards staff, both when they work with you and long after they have left. Your Honour's long-time associate, Julianne Reid, accompanied Your Honour from 3 Wentworth to the court and is now headed with you to the Commission, a testament to your excellent working relationship, shared shorthand in communication, and compatible sense of humour. Your Honour's academic excellence from a young age is reflected on the Honours Board at Knox Grammar School, where you were dux over multiple years, including in your final years. As a school student, Your Honour is described as popular, with a mischievous sense of humour, while clearly being an intellectual giant. There are tales that when Your Honour was sent out of the classroom for some act of side-splitting mischief, you would still listen in to the lesson from outside and undeterred would put your hand through the window to answer the teacher's questions.
It's apocryphal.
Your Honour was Dux of Humanities in your final year, indicating an early aptitude for history, before blitzing the history major in your arts law degree at the University of Sydney. Your close attention to the intersectionality of law and history was no more evident than in Your Honour's delivery of the 2014 Peter Nye Memorial Lecture at the National Family Law Conference on the topic of the history of adoption. The lecture spanned from Babylon circa 2250 BC and Roman law through to the first adoption statute in the common law world in 1851, the provisions of which, you explained, are woven into current adoption law, before outlining the development of international conventions, domestic practice in Australia and law reform. Your Honour's contribution to Nye's conflict of laws in Australia, in particular the chapters on family law, are another testament to the scholarly education Your Honour has bestowed on our profession. Your Honour has assisted with continuing education across the profession, also lecturing on aspects of advocacy, practice and procedure. In a 2008 address on practice and procedure before the duty judge in equity at the Bar Association, Your Honour advised on the elusive art of identifying only truly urgent matters when deigning to rouse the duty judge. Your Honour included some practical advice. If you do persuade a duty judge that you have a sufficiently urgent matter for the judge to sit in court on the weekend, then it is not good form for a counsel to appear in sporting attire when the judge has gone to the trouble of convening a court and robing for the occasion. Your Honour there presciently expressed sentiments judges across the world would find themselves keening to over a decade later during online court in the COVID era. More recently, in 2022, as a judge of the Court of Appeal and Deputy Chair of the New South Wales Law Reform Commission, Your Honour somehow found time to participate in the New South Wales Bar Association Judges Series, delivering a paper on elder law, to lecture on costs as legal conferences, as chair of the Cost Assessors Users Group, and to chair an abundance of committees, as we've heard. These are but a tiny speck in the massive contributions by Your Honour and do not even traverse your extraordinary military service. Your Honour's formidable record of service cannot be mentioned without pausing to salute Your Honour's family and friends, in particular your wife Sue and your children, who have supported Your Honour in achieving each milestone. As Your Honour prepares to leave the court, we note that this ceremony is yet another chapter in the great history of your family's service to the court. Your Honour's father, Justice Russell Legay Brereton, was a judge of this court, as was your godfather, Justice C.L.D. Mears AC CGM QC. Leicester Mears was a former president of the New South Wales Bar Association, the first president of the Australian Bar Association, a leader of the common law and commercial bars, and saw active service in the Second World War. Your Honour's Aunt Robin, your mother's sister, who is in attendance today, was also a long-serving associate in this court to several judges, including your father. Your Aunt Robin's sign that read, Associate to Mr. Justice Brereton, was passed to Your Honour's associate and has been an ongoing reminder of your aunt and father in your own chambers. At other times in his life, Your Honour's father was a barrister at the private bar, a Crown prosecutor, and Deputy Chancellor of the University of Sydney, where he graduated with the University Medal in Philosophy. He also saw active service in World War II, including in the Battle of El Alamein. He was appointed a War Crimes Officer for the famed 9th Division, carefully collecting evidence and later successfully prosecuting the first of the war crimes trials in Lubain, Borneo. Your Honour's unstinting contribution to public life, including Your Honour's lifelong parallel service in the military, rising from infantry officer to Major General, inexorably led to Your Honour's appointment to lead the Inspector General of the Australian Defence Forces inquiry into the conduct of the Special Operations Task Group in Afghanistan. Your Honour's fearless integrity and formidable skills will now be brought to bear in the establishment and shaping of the National Anti-Corruption Commission. D-Day is coming for any serious and systemic corrupt conduct in the Commonwealth Public Service. Your Honour, the Bar thanks you for your truly astounding service, both at our bar and on the bench. We wish you all the very best as you take up your new role as Commissioner. May it please the Court.
Ms. Banks, President of the Law Society of New South Wales.
May it please the Court. I too acknowledge the Gadigal people of the Eora Nation, the traditional owners of the land on which this court stands, and I pay my respects to their elders past, present, and their youth emerging. I acknowledge and extend my respects to any Aboriginal and Torres Strait Islander people here today. Justice Brereton, I rise this morning honoured to represent the solicitors of New South Wales in farewelling you from this court, where you have served for nearly 2 decades. To thank you for your dedicated service to the law and simultaneous extraordinary contribution to the defence of our nation. The law and the military, as we have heard, have been intertwined in your life from birth. Your father, Russell Legay Brereton, a former judge of this court, having prosecuted Japanese war crimes in Borneo. Your Honour's induction to the ranks of solicitors began when you were a signals officer for the Sydney University Regiment. In 1978, your commander, Stuart Cuddy, noticed a very smart young officer who so impressed with his intelligence, application and capacity that he offered you work as a clerk at Duncan, Barron & Co. After admission in 1982, you continued at Duncan Barron, further impressing with your capacity for hard work, becoming much admired and very popular. It is said that Your Honour wanted to do the very best job, whether it was a mention as an agent for a firm in Dubbo or Camden or one of your own clients. Your Honour served on the Law Society's Ethics Committee for 2 years, which speaks to your desire to participate actively in maintaining and strengthening the integrity of the legal profession. At Your Honour's swearing in to this court in 2005, you expressed appreciation to my predecessor, John McIntyre, for his words on behalf of the New South Wales solicitors. Your Honour told this court that your time as a solicitor was invaluable, giving you insight into the practices of solicitors and the demands of their clients. You declared that if ever solicitors were the junior branch of the profession, it is no longer the case. In our number counted, you said, many superb lawyers, the equivalent of the leaders of the bar. I respectfully adopt Your Honour's observation and will not cavil with the description equivalent, at least not in your presence. It was while Your Honour was a junior solicitor at Duncan Barron that a law student, now a silk, spending a day of work experience with you, witnessed the possible genesis of your famed combat with the clock. Following a morning of mentions in and around this precinct, Your Honour said crisply, "Now we have to get to the local court." "How do we get there?" was the reply. Being one who can find swift, effective solutions to the challenges you face, Your Honour exclaimed, "We run." Your Honour is also known for playing chicken with the timetables of international airlines, giving the aircraft an even chance of escaping without you. One of your present colleagues explains that this habit of arriving mostly in the nick of time is in the finest traditions of General Sir John Monash, who was famous for arriving at meetings at the last minute. On time, but at the last minute. This is not a defect, your colleague says. You have so much to fit into a day, let alone your life, that sitting around in an airport lounge isn't a good use of time. I'm reminded of Tolkien's wizard Gandalf, who is never late, nor is he early. He arrives precisely when he means to. The practice at Duncan Barron afforded Your Honour much opportunity to be an advocate, impressing the judicial officers before whom you appeared. To Stuart Cuddy's enduring sorrow, in 1987, the branch of the profession he describes as the opposition stole you away, the chief thief being Justice Michael Kirby. Once ensconced at the bar, solicitors were eager to brief you. Your former boss bemoans that you were so busy that he found it difficult for you to accept a brief from him. At the bar, you were regarded as a true generalist in an era where generalists were dying out. It is said that most self-described generalists cover around 50% of the law, where your practice covered around 85 to 90% of the law. One might say that Your Honour was a major generalist. Some who've observed Your Honour at the bar afterwards maintain that you have forgotten more about the law than they would ever learn. It's possible that that is right, but I suspect that you have forgotten nothing. Your Honour's conduct of cases at the bar is likened to that of a seasoned commander, surveying the battlefield from every possible point of view, deploying your forces to achieve your objectives. Your Honour was appointed to the Supreme Court in 2005 and elevated to the Court of Appeal in 2018. I don't propose to repeat Your Honour's remarkable achievements that have been canvassed already. However, I cannot let go unremarked Your Honour's talent, particularly in the corporations list, for delivering, after a long hearing day, very clear extempore judgments on complex matters with apparent ease. Your former tipstaff says this is because you prepared, in many cases, in much more detail than the parties expected. Suffice to say, Your Honour leaves this court with well-deserved admiration of your intellect, humanity, clarity, and capacity for hard work. Nowhere was this capacity tested more thoroughly than during the inquiry you led, which resulted in the Brereton report. Colleagues would bump into you as you left this building at the end of a full working day, briefcase in hand, to head to Defence Plaza down in Pitt Street to work into the night on the inquiry. Your fine legal mind, combined with your understanding as a long-serving infantry officer of land operations, made you the perfect appointee. Each person we spoke to who was familiar with Your Honour's work on this inquiry either described it as, or agreed it was, the most significant inquiry that's ever been conducted in the history of the Australian Defence Force. General Angus Campbell, the Chief of the Defence Force, said, Your Honour's inquiry laid bare very confronting aspects of our military experience in Afghanistan. His work will continue to significantly influence the current and future development of the Australian Defence Force and will have a profound, broad-based and ultimately very positive effect on the institution and its people. Accountability and integrity are central to the new role Your Honour takes up later this week at the National Anti-Corruption Commission. Your Honour is described as a man who is relentless in pursuit of the truth. You are driven by the highest ideals for a better society. General Campbell put it well. This is an extremely important position, and I cannot think of anyone more eminently qualified to undertake this role. Your Honour, I want to conclude these remarks with an acknowledgement of your immense contribution to the Children's Care and Protection jurisdiction, and I thank you for the commitment, diligence and care you have shown in this important area. As you once wrote in a paper about children's issues in the Supreme Court, it is a jurisdiction that is wide-ranging and far-reaching. In theory, it is unlimited. And in another paper, the area of law that concerns the welfare of children is second in importance only to that which deals with the liberty of citizens. Your Honour has demonstrated care, grace, and a strong fidelity to both the law and the welfare of the child and family whose cases have come before you. For all that Your Honour has done for the law in New South Wales and in your service to the nation through your military appointments and duties, the Solicitors of New South Wales thank you. For the dedication, integrity, determination and fortitude you'll demonstrate in your new position, the people of Australia will be grateful indeed. May it please the Court.
Thank you, Mr. Banks. Justice Brereton.
Chief Justice and my fellow judges of the court, Ms Bashir, Ms Banks, judges, ladies and gentlemen. I too acknowledge the Gadigal people of the Eora Nation who since time immemorial have cared for and been the custodians of the land on which this courthouse stands. I pay my respects to their elders, past, present and emerging, and also to all First Nations people participating in this ceremony. Thank you, Chief Justice, Ms Bashir and Ms Banks, for the altogether too generous sentiments you have expressed. The industry of your agents is impressive, the discretion of their sources more so. But you have not failed to leave some ammunition for cross-examination. Beginning with Ms Banks, beginning with Ms Bashir, I have never in my life drunk tea. The apocryphal pot of tea of which you speak may have been an endless supply of coffee. And so far as Ms Banks is concerned, at a function a few weeks ago at the Law Society, I observed in the course of my speech that I would be concerned if I saw her speaking to members of the military legal service present, because I would know there was an information operation afoot to gather intelligence for the speech to be made today. Ms Banks then represented to me that she would not be here but in Burke. Whether that representation was made honestly believing it to be true at the time or not remains to be seen. For the Chief Justice's remarks, I will reserve my reply for another occasion. I am deeply honoured and greatly touched by the presence of so many whose lives have touched me over such a long period. For the Court, this is yet another rotation of the vital wheel of continuity and renewal to which these ceremonies bear witness. For me, it marks, at least nominally, an event which I've always contemplated with dread, alleviated until very recently by knowing that it would not occur for another decade when I will attain the present age of provisional statutory senility. I'd always envisaged being here at least until then, and provisionally for another 3 years thereafter. And I was quite depressed to discover at a school reunion last year so many of my contemporaries were either already retired or contemplating retirement. I embark on retirement only in the most technical legal sense, as to assume my impending appointment, the governing statute requires that I must hold the qualification of being a retired judge. And while I'm very grateful to those who've kindly written wishing me a very long and happy retirement, that perhaps misses the point. In recent days, a somewhat funereal procession through my chambers, and yesterday my courtroom, of all manner of people, judges, barristers, registry staff and court officers who have come to say their goodbyes, has moved me greatly. You have successfully created a real semblance that I will be missed. However, your efforts are easily undermined. Late last week, we received a statutory demand from the Chief Librarian for the delivery up of books which the library claims to have purchased from my library allowance. One of them, On Equity, by the Honourable Peter Young, bears the autograph of its author. I think that might be of evidentiary value when tendered in my defence to any claim indebted. Then, yesterday, the fleet manager's agent arrived at home to repossess the family car. This brought to mind my late dear mother's lifelong lament that when my father died in office, the first she heard from the Department of Justice was a demand for the surrender of his gold pass. No doubt when the court adjourns, there will be someone waiting outside to collect its modern-day equivalent, the blue Opal card. You've heard some somewhat eloquently embellished accounts of my career. For whatever truth there is in them, those responsible are the institutions and the people in them who have shaped my career and characteristics. My family, Knox Grammar School, the University of Sydney, and particularly its Students' Representative Council, the legal profession in both its branches, the Australian Defence Force, and the court. My father had already been a judge of the court for 5 years when I was born. His example has undoubtedly been my greatest influence. There remained a few who bridge the gap between the generation of lawyers who knew him and the present, most notably the Honourable Michael McHugh and the Honourable Michael Kirby. I think he would be as pleased as am I that they honour me by their presence today. I'm very grateful for the work Tony Cunneen has done to rekindle his memory, as he has the memories of other members of the profession who have served in the Defence Force. After his death, my mother devoted herself to her children well beyond the call of duty. I did not realise for many years that she eschewed the prospect of what the family lawyers today call repartnering, in the belief that my brother John and I would disapprove. We both owe her very much. Although my father and mother are no longer with us, my remarkable aunt Robin Stevenson is. Her connection with the court began as my father's associate for more than a decade from the early 1960s, and after his death as associate to Justice Arthur Rath for another decade. It was under her wing that I was permitted to frequent the courthouses around the state where first my father and later Justice Rath would sit, and where my interest in the law was germinated. As a clerk and solicitor at Duncan Barron and Company, Stuart Cuddy allowed me great scope and latitude, from which I acquired experience far beyond what could have been gained at a large firm, and also a stable of regional firms for whom we were Sydney agents, many of whom would come to brief me at the bar. It was while I was there that I first encountered two individuals who would later become influential: Chief Justice Bathurst, then a junior barrister against whom I conducted my first case in this court before Justice Powell, and Justice Peter Young, before whom I conducted another case, and the outcome of which I then briefed Bathurst to defend on appeal. It's no accident that two other employed solicitors of that firm in that environment have also attained judicial office: Justice Meek of this court and Magistrate Day. And that is why so many of my tipstaves have been guided in the direction of small and regional firms to begin their legal careers. It was, as you have heard, a predecessor president of the Students' Representative Council, by then President of the Court of Appeal, Justice Kirby, who persuaded me to leave a position in which I was very comfortable and content and to move to the bar. The role of the bar in the administration of justice is indispensable. The proliferation of decisions, both reported and unreported, means the days when a judge can know almost all the relevant law are gone, and the court is reliant on counsel to discover the relevant authorities. And robust clinical cross-examination is as critical as ever to exposing the truth. The opportunity for it is one that I think is nowadays sometimes too readily forgone. My diverse practice at the bar took me to many forums, including often to the family court. I'm especially pleased to see here today the Chief Justice and judges and practitioners, past and present, of that court, now the Federal Circuit and Family Court, including some, like the Honourable Mary Finn and the Honourable Stephen O'Ryan, before whom I often used to appear. Others like Justice Campton, Richardson of Senior Counsel and Carney of Senior Counsel, who were my opponents and or juniors. Still others like Justice Christie, who has often appeared before me. My interest in family law did not abate on coming here, and I suspect there may have been a view abroad that an application to transfer a matter from my list under the cross-vesting jurisdiction to the family court might encounter judicial resistance. I have endeavoured to incorporate your court's jurisprudence into more general legal discourse. As late as last Friday, in this court's judgment in Cleaning Doctor, reference was made to the marriage of Sutcliffe, a 1988 decision of Chief Justice Nicholson and Justices Strauss and Nye. Indeed, when Chief Justice Bathurst approached me to join the Court of Appeal, he imposed a condition that I disavow rumours that I was going to accept an appointment to your court. There were other conditions, but I do not believe that any is breached by my retirement to accept appointment to the new commission, if only because it had not then been conceived. It was another predecessor president of the Students' Representative Council, this time Chief Justice Spiegelman, who persuaded me to leave the bar, where again I was comfortable and content, to come to this court. In the Equity Division, I served with three occupants of the great office of Chief Judge in Equity: the Honourable Peter Young, the Honourable Patricia Bergen, who is here, and the Honourable Julie Ward, who of course is now the President and has been a friend since law school days. From the example of Peter Young in particular, I learnt that the role of a judge was to adjudicate cases, not to cajole or bully the parties into a settlement. If they wanted their day in court and a judge to decide their dispute, they were entitled to have it, however poor the prospects and however small the dispute might seem to us. I learnt also that the immediately obvious answer is not always the correct one, and that not infrequently underlying an apparently querulous grievance is a legitimate complaint, which, had it been discerned and resolved earlier, might have avoided tremendous trouble. When Chief Justice Bathurst invited me to become Corporations List Judge, I was left under no misconception that it was expected that I should recapture jurisdiction that was seen to have been lost. My unabashed aim was to make our Corporations Court the premier Corporations Court in the Commonwealth, even if it meant sometimes seizing rather than relinquishing jurisdiction. I gather it was sometimes said that so long as a corporation was mentioned somewhere in the pleadings, even if merely the owner of the horse, it was difficult to persuade me that it was ineligible for the list. I knew we'd made some progress when I heard the Melbourne solicitor Leon Zweier say at a conference that our court was his firm's preferred forum for corporate schemes of arrangement, although he did bristle a little when I characterised New South Wales as the Delaware of the Antipodes. The intellect and industry of Justice Ashley Black, including his textbooks and commentaries as well as his judgments, was instrumental in whatever was achieved there. The adoption jurisdiction is less visible, but second in importance only to that which pertains to the liberty of citizens. It determines the future lives of vulnerable young people. As social policy has evolved, so has the nature of the court's adoptions work. The input of an engaged users group led by Ms. Nicole Hailston of the Crown Solicitor's Office enabled the reform of adoption practice, better to support open adoption, and with it, the sustenance of some connection between child and birth family to mitigate future identity issues. I'd also like to acknowledge the work of the costs assessors who inconspicuously perform a vital function in the administration of justice, and the members of the Cost Assessment Rules Committee who've supported the major review and overhaul of the scheme initiated by Chief Justice Bathurst, and as one of its most important practical outcomes, promulgated and recently updated a guideline on costs allowable on party-party assessments, which in the current scale-free environment operates as an important informal control to support access to justice. The Court of Appeal today, frankly, is not what it was 55 years ago. Then it was regarded by the bar with fear and by the judges of the divisions, particularly those of the Common Law Division, with loathing. The division and dissent wrought by its creation lingered for decades. It took the calming and cordial presidency of the Honourable Michael Kirby eventually to assuage it. Today it is a collegiate and courteous court whose judgments are more widely cited than any court in the land save only the High Court. Guiding my approach as an appellate judge, I recalled what was said by the then Vice President of the Bar, D.G. McGregor QC, later a distinguished judge of the Federal Court, when addressing the ceremonial sitting in the old Banco Court on the occasion of my father's death. Referring to his time as a member of the full court prior to the creation of the Court of Appeal, McGregor said that he was not one merely to concur, though he may dissent, that he seemed almost always to contribute his own separate judgment, and that one was struck with the disparate subjects on which his writings dwelt. Reference has been made to my military service, and I'm honoured by the presence, actual or virtual, of 3 generals of the Army, Major General David Tomai, Commander of the 2nd Division and of the Queensland Bar, Major General the Honourable Justice Greg Gard of the Supreme Court of Victoria, and Major General Greg Meddock of Senior Counsel. On the bench also is Rear Admiral the Honourable Justice Michael Slattery. Amongst the audience are many of my sometime commanding officers, Colonels the Honourable Bill Windier, Stuart Cuddy Solicitor, Frank Windier Solicitor, Maurice Neal of King's Counsel, and Andrew Morrison of Senior Counsel. When in 2005 Chief Justice Spiegelman telephoned me to ascertain my interest in an appointment, I was in a picturesque little valley, known to some of you as Monkey Place Creek in the Singleton military training area. According to my recollection, and he is not here to dispute it, he said to me something to the effect, "I can't stop you doing whatever it is you do with the Army." As a matter of law, he was of course correct. Justice Gard, when he was head of reserves, drafted the Defence Force Reserve Service Protection Act with sufficient prescience that it covered not only employees, but also those holding appointments under the Commonwealth or estate. I'm nonetheless deeply grateful to the successive Chief Justices, Presidents and Chief Judges, and my fellow judges who have tolerated, supported and enabled my extracurricular activities. As Tony Cunneen's forthcoming chapter in the bicentennial history will show, the Court has traditionally and historically afforded great support for our defence reserves. Ultimately, both institutions benefit. From our military service, we learn much about our fellow human beings, which better equips us to understand, to represent, and ultimately to judge them. The story of the Afghanistan inquiry cannot yet be told, though it must be one day. I am touched to see here so many of the team who undertook that historic work, some like Captain Rennick and Commander Vesper masquerading as barristers, as I am also to see the Inspector General of the ADF, under whose auspices the inquiry was conducted, Mr. Jim Gaynor, who was himself many years ago a tipstaff in this court. And I'm very grateful, Ms. Banks, for the words that you have conveyed from General Campbell, the Chief of the Defence Force, who has demonstrated great moral leadership, first in seeking and supporting an inquiry which was never going to be popular, and then in courageously presenting and addressing its outcomes and recommendations because it is the right thing to do. As our report concluded, despite discovering things which we did not hope to discover, every one of us remains proud to be a member of the Australian Defence Force and of the men and women who serve in it, overwhelmingly with proficiency, dedication, and honour. They live those same ideals of service and duty which equally permeate the legal profession. But although being a General of the Army ranks a very close second, to have served on this court has been the greatest honour and privilege of my life. For me, at least, that is accentuated by the traditions, institutional as well as familial, in which I step. When over the last few weeks the Chief Justice has permitted me to preside at a number of admission ceremonies, in his words, because, like an elite athlete, my workload was tapering, I have, in addressing the newly admitted lawyers, elaborated on his theme of continuity of the rule of law in this state. This court is nigh on 2 centuries old. That we wear the same robes as our predecessors, in my case very literally so, symbolises the enduring continuity of the rule of law, encapsulated in the judicial oath to which each judge of this court subscribes, to do justice to all manner of people without fear or favour, affection or ill will. We must and do acknowledge that the imposition of foreign laws on the First Nations, including in times past by this court, has wrought many hardships and injustices. But it is important also to recognise that as long ago as 1838, it was the unstinting adherence to the rule of law by law officers and the court in the face of public hysteria that resulted in the conviction of those responsible for the Mile Creek massacre of 28 Aboriginal men and women in northern New South Wales. This has been a wonderful place to work, populated by wonderful people and led in the best traditions of the court by 3 great Chief Justices. How fortunate we are in the support we enjoy was never better brought home to me than when I had the privilege of sitting in the Royal Courts in the Strand for a fortnight, with the present Chief Justice and Julian Sexton of Senior Counsel as leading counsel, and seeing the conditions with which our counterparts there cope. Or when I recently hosted here a visiting Lord Justice of Appeal who envied our facilities and resources. To all those who have been part of that, the Chief Executive Officer and his staff, the registrars, the adoptions clerk and the court officers, I am very grateful. I'd especially mention the Manager Costs Assessment, Brendan Bellick, and the Pathonetary Rebel Kenner, who over the years have assisted me in many ways. Many of those who have been my tipstaves are here, others are observing online. I hope they've enjoyed our relationships as much as I have. One of the most satisfying aspects of judicial life is to see these young men and women flourish into their own careers. On the other hand, only one of my associates has been able to make it. The remarkable Julianne Reid. This is her farewell too, though she has inexplicably chosen to follow me to Canberra, for which I am very grateful. Training a new associate at this stage might have been a bridge too far. I'm immensely indebted to you, Julianne, for your loyal service, now over more than 2 decades, including for a few years before I came to the court. So too is the court. Your vast corporate knowledge of its workings will be greatly missed by the many who have drawn on it. When I was appointed, Sue and I were relatively recently married. Josephine and Catherine were just 5 years old. Sue, who is watching online, has now, for longer than a life sentence and without any expectation of parole in the sense that I might ever really retire, tolerated my defects, repaid them with love, support and affection, ensured that I do not take myself too seriously, and in the meantime carved out her own outstanding career in alternative dispute resolution. Josephine and Catherine were about to sit their high school certificate when I came to the Court of Appeal in 2018. They both now are embarked on their own careers, Josephine in music and Catherine in New Zealand in agricultural commerce and research. I'm tremendously proud of all of you. And finally, the future. Those who await my first comments about the new Commission will have to wait a little longer. This is not the occasion for that. But I suppose you are entitled to some reasons. My father once said to me that he had always wanted to do something for Australia and that he hoped that I might. Today I sense a tide in the affairs of the nation, which taken at its flood might significantly shape for the better the governance of our Commonwealth. It is a unique opportunity to build and lead the Commission that can do that, one which will draw on all my experience in all my careers that has persuaded me to exchange this setting where once again I am very comfortable and content for these new challenges. When I spoke here nearly 18 years ago, reflecting on the judicial oath and repeating my godfather Lester Mere's response at his swearing into this court, I said, I too will do my best. In a case in the High Court in 2001, which Justice Gageler will remember because he was led in it by David Bennett, Queen's Counsel Solicitor General, who in turn was led by Darryl Williams, Queen's Counsel Attorney General, called Patterson Ex Parte Taylor, which has recently gained some notoriety because of my unsuccessful argument that the appointment of multiple ministers to one ministry was constitutionally impermissible. Another issue was the scope of the aliens' power. A more successful argument, inspired by my junior counsel David Ash, identified as the essential body politic of the Commonwealth, who were not aliens and not amenable to the aliens' power, the people of the Commonwealth. Now I leave this place, not without sadness, but to serve the people of the Commonwealth. Moved and inspired by the confidence so many have expressed, once more, I will do my best.
Thank you, Justice Brereton. The court will now adjourn.
All stand. This honourable court is now adjourned.